Thank you for joining Mayor Brown's webinar. Our program today will focus on conflicts, confidentiality, and privilege. I'm Chuck Regan. I'll give a proper introduction in a second, but let me cover a few administrative matters before getting started. First, at the bottom of your screen, you'll notice there are multiple application widgets you can use. All the widgets are resizable and movable, so feel free to move them around to get the most out of your desktop space. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner. Today's program is being streamed through your computer, so there is no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so you can hear me. For the best viewing experience, we recommend using a wired internet connection, preferably with Chrome or Firefox browsers, and closing any programs or browser sessions running in the background that could cause issues. Some networks cause slides to advance more slowly than others, so logging off your VPN is recommended. If your slides are behind, pushing F5 on your keyboard will refresh the page. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. During today's presentation, you'll be provided with an alphanumeric code. If you're applying for CLE credit, you will need to record this code on the virtual sign-in sheet that you received by email with the connection details. You can also find a copy of the virtual sign-in sheet in the resource list widget entitled CLE Affirmation Form. Directions for returning the CLE affirmation form are on that sheet. I will read the code in the middle of the presentation and then again at the end. Please note we also made the event evaluation form and presentation deck available in the resource list widget for your convenience. This webinar is being recorded as we normally do with these programs. In a day or so, we will be sending you an email with a link, which you can use to listen to the webinar again or share with your colleagues. The recording will also be posted on our website. I plan to allow time at the end of the program for questions. To submit a question electronically, please use the Q&A widget. If I don't get to your question during this webinar, I'll make every attempt to follow up with you after the webinar. So with that, good morning, good afternoon to those of you on the East Coast. I'm Chuck Regan. I'm a partner in Mayor Brown's Chicago office, but like you, I'm an in-house lawyer. I act as the firm's lead conflict lawyer and a member of the professional responsibility and loss prevention team. At a large law firm like ours, with a broad practice across a number of offices around the world, conflicts are a recurring and often difficult issue. I spend full time addressing these and other professional responsibility issues. Because I'm a conflicts lawyer, I'm going to talk about conflicts issues to start. Now, since you're representing one entity or related set of entities, you will face conflict issues much less often than we do. But you do need to consider conflicts when we or your other outside counsel ask for waivers, and there are some instances where you might need to think about conflict issues for your own entity. I'll also talk about the conflict issues raised by lateral attorneys and discuss a recent case where an entire in-house legal department was disqualified because of a conflict that a lateral attorney brought with her. I'll then move on to discuss a lawyer's duty of confidentiality, which is pretty straightforward, and from there go on to discuss the application of the attorney-client privilege to in-house counsel, the subject that is anything but straightforward. I have a good bit to cover, so for the most part, my presentation will be at the 30,000-foot level. So let's jump in. I'll start with, as I said, a discussion of the conflict rules. My citations today will be to the model rules of professional conduct. Now, 49 states and the District of Columbia have adopted some version of the model rules. In California, the last holdout has recently announced it's revising its rules to follow the format of the model rules effective November 1st. But in adopting the rules, the states often, I think it's accurate to say actually always adopt certain changes. So in looking at these issues or any issues under the rules of professional conduct, you and we have to look at the rules adopted in the relevant state. The first rule to consider here is Rule 1.7A1, the prototypical conflict rule. A law firm cannot be directly adverse to a client without the consent of both clients. There are two aspects to this. First, you cannot be adverse to a client, even in an unrelated, non-contentious matter, without the client's consent. So if I'm representing a bank in a regulatory matter, I cannot represent a manufacturer in seeking a loan from the same bank unless the bank consents. Second, and lawyers sometimes forget this, you cannot represent a client's adversary without the client's consent. So let's modify the example I just gave. I'm representing a bank and making a loan to a manufacturer. So the bank is the client. The manufacturer then comes to one of my colleagues and asks her to represent it in a regulatory matter. It's unrelated to the loan where I'm representing the bank, and the bank is not a party to the regulatory matter. Nevertheless, I need to get the bank's consent to represent the manufacturer. Reason for that is that I'm being disloyal to the bank if I represent the adversary, that there is a conflict of interest. The concern is that because I want to curry favor with the manufacturer, which is now a client, I will not push the bank's interests as hard in the loan matter against the manufacturer. So I need consent from both the bank and the manufacturer in this example. Lawyers sometimes forget adversity is not contentiousness. Sitting across the table from a client in a friendly negotiation is adversity for purposes of the conflict rules because the interests of the parties are different. As I noted, Rule 1.7 implements a duty of loyalty. I'm going to make a brief digression here to talk about the rules in Europe and Asia, something I have to deal with on a daily basis. Rules outside the U.S. do not include a duty of loyalty. Law firms can be adverse to clients in matters not related to the work that the law firm has done for it. Another way to look at it or to put it is the rules in Europe and Asia are matter-centered, unlike the U.S. rules, which are client-centered. Now, there's still some restrictions under the rules in Europe and Asia. As the slide says, a lawyer or law firm cannot act for multiple parties in the same or related matter if their interests are not aligned. That is, if there is a conflict or significant risk of conflict between them. And that sort of conflict is generally not waivable. Now, obviously, even though the European and Asian rules allow lawyers to be adverse to their clients, there are still client relation concerns, especially in contentious matters. Move on to Rule 1.7A2, which deals with the more subtle or harder to recognize sort of conflict, the so-called material limitation conflict. Rule 1.7A2 says a conflict exists, requiring consent from the affected client, when there is, quote, a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client or a third person, or by a personal interest of the lawyer. Now, there's some judgment involved here. Since the rule talks in terms of significant risks that the representation will be materially limited. Under Rule 1.7A2, a representation might be limited by responsibilities to another client. This might happen in a joint representation context, where a lawyer's ability to recommend the full range of options to an individual client might be limited because of the responsibility to the other jointly represented client. Or the representation might be limited by the interests of the lawyer or law firm. For example, you have a friend or relative at an adverse party in a contentious matter. But that sort of material limitation would only be personal to the attorney and wouldn't be imputed to the other attorneys in the firm. Now, under the U.S. rules, if I represent a client, I may also be unable to be adverse to its affiliate without consent. This question is one of the most difficult questions that we conflict lawyers face on a day-to-day basis. As a general matter, corporate affiliation by itself does not create a conflict. As I say up on the slide, comment 34 to Rule 1.7, a lawyer who represents a corporation or other organization does not, by virtue of that representation, necessarily represent any constituent or affiliated organization, such as a parent or subsidiary. Likewise, ABA Opinion 95-390, the fact of corporate affiliation without more does not make all of the corporate clients' affiliates into clients as well. The opinion also says the model rules of professional conduct do not prohibit a lawyer from representing a party adverse to a particular corporation merely because the lawyer or another lawyer in the same firm represents, in an unrelated matter, another corporation that owns the potentially adverse corporation, or is owned by it, or is, together with the adverse corporation, owned by a third entity. But comment 34 and the opinion notes three possible exceptions to that general proposition, where there could be a conflict in being adverse to an affiliate of a client. First one they note is where the affiliate can also be considered a client, something that depends on the facts and circumstances. One of the factors that you look at is whether there's an integrated legal function that covers both the client and the affiliate. That makes sense as a practical matter. If I'm dealing with an in-house lawyers daily on the matters where I represent the client, it will be awkward to be adverse to the same group of attorneys, even if they are technically representing an affiliate. Other things to consider are the client and the affiliate in the same line of business, or we have confidences from the client that also apply to the affiliate. The other exception that the rules and the opinion note are where the lawyer's obligation to either the organizational client or the new client are likely to limit materially the lawyer's representation of the other client. This is most likely to come up where we have an extensive representation of many parts of the corporate family, even if we don't represent that particular entity. And the third exception is where the law firm and client have an understanding that the firm won't be adverse to affiliates. Many clients do indicate in their outside counsel policies that for conflict purposes, a law firm is deemed to represent all members of the corporate family. And whether we agree to that is something we have to decide as a business matter. And we do in many instances where we have an established and extensive relationship with a client. Even where we're willing to agree to consider the whole corporate family as our client, we often need to clarify. The outside counsel policies often refer to the affiliates, and that term is not usually or is not well defined. It will be unclear in any number of situations. So we much prefer in those sorts of instances, to have a list of affiliates that should be considered part of the corporate family that we can add into our database. So if we have a conflict, we will not be able to proceed unless we get waivers. Rule 1.7b sets forth the protocol for waivers. Number one, the lawyer must reasonably believe that the lawyer will be able to provide competent and diligent representation to each affected client. Now, I think that's rarely a problem for a law firm as a whole. Our lawyers can generally provide competent and diligent representation adverse to a client that another lawyer in the firm represents. But sometimes it's an issue for an individual lawyer who feels, I've done too much work for this client, I can't be adverse to it. Second requirement is the representation is not prohibited by law. And that's rare. Sometimes laterals coming out of the government will have issues with that. Third, members of the same law firm cannot be adverse to one another in the same litigation. And fourth, each effective client gives informed consent, confirmed in writing. I will note that the last provision, the last clause of number 4, confirmed in writing, doesn't apply in Illinois, although we always want to get conflict waivers in writing anyway, so there's no, so that there is no question about what has been waived and that the client has agreed to it. One question that I often get is this a conflict that can be waived? I think the answer, at least for large law firms, is yes, 99% of the time or more. If we can protect the confidential information of both clients, then we should be able to proceed. The only possible exception in my mind is when an individual lawyer has represented a client and then another client asks the same lawyer to be adverse to the first client. And the lawyer has confidential information from the first client that is relevant to the matter for the second client. The lawyer cannot screen one side of her brain from the other. But again, that's not a problem for other lawyers in the firm. That may just mean that that particular lawyer cannot be on the new matter. Now, the case law and the ethics opinions recognize that For a waiver to be effective, the consent has to be informed. The lawyer has to give sufficient detail so that the client can make a decision. Waivers are, as a general matter, narrowly construed. If it doesn't say litigation, it may not be construed to cover litigation. And as I already said, most jurisdictions require consent to be confirmed in writing. Now, for the most part, for people who work in an entity, you're going to have conflict issues much less than we do. And that's true even if you're representing multiple entities in your organization because the interests are aligned and there's no real conflict. But that's not always the case. What you need to think about is whether someone might claim, either now or in the future, that the interests of the two entities differ and that one lawyer or set of lawyers cannot adequately represent both sides of the transaction because its representation was materially limited by responsibilities to the other client. If so, it may well be appropriate to have separate sets of lawyers to represent each side. Best example of this is probably representing both a private equity fund and a portfolio company, especially if the portfolio company is being prepared for sale. I'm going to talk now about some of the ethical rules that are brought into play when a lawyer represents an organization or entity. Now, these are issues that both you and we face. Most of our clients are organizations or entities of some sort. These issues are addressed in Rule 1.13. Section A of that rule emphasizes that when a lawyer is retained by an organization, he or she represents the organization, not the individuals who run it. This is the so-called entity theory of representation. Section A also recognizes the reality that an entity can only act through individuals. And so the lawyer represents the organization, acting through its duly authorized constituents. There's sometimes, as I say on the slide, a tension between these two aspects of Rule 1.13a. That is, between the duty to the organization, which is the client, and the relationship with the persons who run it. In most cases, this is not an issue, since the persons who run the organization have the best idea of how to advance the organization's interest. Most important thing, it seems to me, is to recognize that there can be this tension, but that ultimately, the lawyer's professional loyalty must be to the client organization. Rule 1.13g recognizes that it can be appropriate to represent both an entity and one of its constituents as long as there are no conflicts. But you need to think about at least two issues in advance. First, what happens if an unforeseen conflict does develop? You want to be able to continue to represent the entity, your main client, and you need to make that clear up front. And second, what to do with confidential information that is learned from both of the clients that are represented. So in addition, if you are representing only the entity, but in doing so you're acquiring information from or otherwise dealing with one or more of the entity's employees, you generally need to make it clear that it is the entity that you're representing and not the employee. That's Rule 1.13f, which says, in dealing with an organization's directors, officers, employees, members, shareholders, or other constituents, the lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. Now, this provision is probably intended to protect the employee or other constituents who may not understand your role. But it protects you as well, you as the lawyer as well, by avoiding a later complaint by the constituent that you were representing him or her and that you violated duties you owed the constituent as a client. The prohibition in Rule 1.13f is just a specific application of Rule 4.3, which I've not put on the slide, about dealing with unrepresented persons. When you have to deal with someone who's unrepresented, you cannot imply that you are disinterested. That's because you do have an interest, that of the client. You must also correct a misunderstanding as to the lawyer's role in the matter. And you can't give legal advice if there's a possible conflict, except the advice to the unrepresented person to obtain a lawyer. Moreover, as I'll discuss later in the context of privilege, you probably need to tell the employee that the company can decide to disclose what the employee tells you. Now, one of the issues that law firms face on a recurring basis, unfortunately, is a motion to disqualify, sometimes based on the law firms taking on a matter against a former or current client, but also sometimes based on who a lateral lawyer represented at his or her prior firm. Now, an in-house legal department shouldn't face the first situation, since it only represents the organization in its affiliated entities. But in a recent case, an in-house legal department was disqualified because of the work one of its lawyers did at her prior employer. Let me explain how this came about. To do that, I need to describe some of the background, or some of the relevant background rules about lateral lawyers. I'll start with the conflict rule regarding former clients. As a general matter, lawyers can be adverse to their former clients, except in matters that are substantially related to the work the lawyer did for them. If the matter is substantially related, consent would be necessary. That's Rule 1.9a, and I've included the text on the slide. For the rule to apply, that is Rule 1.19a, the new matter has to be both materially adverse, which is a concept pretty easy to figure out, and substantially related. Comment 3 to Model Rule 1.9 defines that latter term as follows. Matters are substantially related for purposes of this rule if they involve the same transaction or legal dispute, or if there otherwise is a substantial risk that confidential factual information, as would normally have been obtained in the prior representation, would materially advance the client's position in the subsequent matter. As this language indicates, the rule is meant to protect the former client's confidential information, even though that concept isn't mentioned in the text of the rule. So a lawyer cannot be adverse to his or her former clients in substantially related matters. What about the other members of the lawyer's firm? Normally, when one lawyer in a firm has a conflict, generally all lawyers have a conflict. That's Rule 1.10. And you should note that for these and other purposes under the rules of professional conduct includes, quote, lawyers employed in the legal department of a corporation or other organization. Now that's the general imputation rule, Rule 1.10. The rule is a little bit different for a lateral. The lateral still cannot be adverse to the former client. The lateral represented in a substantially related matter at a prior position. But the question then becomes, to what extent does that disqualification get imputed to the other members of the lateral's new firm? The imputation rules for lawyers vary from state to state. Under the model rule, screening will cure imputation, so that the conflict will not be imputed to the lateral's new colleagues. But the new firm is required to give notice to the lateral's former client. Not a lot of states have adopted this yet. I know that North Carolina has, but not a lot of other jurisdictions have as of yet. In Illinois, screening by itself will cure imputation. That's Rule 1.10e. And no notice to the lateral's former client is required. In California, New York, and Texas, screening, and in other states as well, but those are ones that we have to deal with because we have offices there, screening will not cure imputation. You need to get consent from the lateral's former client if there is a conflict that the lateral has. Now, I will note that screening is sufficient to cure imputation for former government lawyers, which is Rule 1.11. So these are the background rules for the recent case. And I'll discuss that in just a second. The case in question is called Dynamic 3D Geosolutions versus Schlumberger, down in the Western District of Texas in federal court there. Our protagonist was an in-house patent lawyer at Schlumberger. She lateraled over to Dynamic 3D Geosolutions, which some would refer to as a patent troll, or more politely, a non-practicing entity. Dynamic purchased the patent and then brought infringement suits against a number of companies, including Schlumberger. Schlumberger moved to disqualify Dynamic's legal department and outside counsel. The court first concluded that the lawsuit was substantially related to work the lateral had done. While at Schlumberger, she had advised on at least an earlier version of the product that Dynamic now asserted was infringing. Because the work was substantially related, the court disqualified the lateral. Dynamic argued that the usual imputation rules that apply to law firms should not apply to its legal department. But the court shot that argument down, citing the model rules definition of the firm to include in-house legal departments, which I read a little bit earlier. The court went on to presume that the lateral had shared relevant confidential information she learned at Schlumberger with her co-workers at Dynamic. And even though there was a screen, Dynamic couldn't rebut this presumption. The court found that the lateral had met with her Dynamic colleagues and with outside counsel about the action against Schlumberger, notwithstanding the screen. And I suppose one should say the supposed screen. The court disqualified both the other in-house lawyers as well as outside counsel for Dynamic and dismissed the case without prejudice so that Dynamic could file suit prepared by lawyers who did not suffer from the conflict. Dynamic appealed the ruling, but the Federal Circuit affirmed across the board. So what does this mean for you? Like law firms, corporate law departments need to determine whether lawyers they're hiring have in their prior positions represented adverse parties against the company. If so, and if the matter is still ongoing, and depending on the rules of the relevant jurisdiction, the company may need to get a waiver from the other side. It will at least need to erect an effective screen that prevents the sharing of confidential information the lateral learned in the prior representation. So that brings us to confidentiality. The model rules version of Rule 1.6, which implies in most states, is pretty straightforward. Lawyer is required to keep all information relating to the representation of a client confidential. All information relating to the representation of a client confidential, unless information falls into a specific exception. Now, I will note that New York's approach is somewhat different. In New York, lawyer is only barred from disclosing confidential information. That is, information is only barred from disclosing confidential information. That is, information gained during or relating to the representation of a client, whatever its source, that is protected by the attorney-client privilege, likely to be embarrassing or detrimental to the client if disclosed, or information that the client has requested be kept confidential. In New York, confidential information does not ordinarily include a lawyer's legal knowledge or legal research, or information that is generally known in the local community or in the trade field or profession to which the information relates. Now, Rule 1.6b includes a number of exceptions to the general rule of confidentiality. I've noted two of them on the slide. One, to prevent reasonably certain death or substantial bodily harm. Or two, to prevent the client from committing crime or fraud reasonably certain to result in substantial financial injury where the client has used or is using the lawyer's services. These exceptions are not to be invoked lightly and are to be applied narrowly. Now, I won't go into this, but different states have different views of when it is appropriate to disclose otherwise confidential information. So they've adopted different exceptions. So if this is ever an issue for you and you have to decide what needs to be disclosed, you'll need to check the rules in your jurisdiction. I'll now discuss the attorney-client privilege and discuss that for the remainder of the presentation. Now, different definitions of the privilege, but as a general matter, the privilege protects confidential communications between lawyer and client for the primary purpose of obtaining or rendering legal advice. These three aspects of the privilege will be the main focus of what I'll be talking about today. But a few preliminary points before I get to them. First, privilege is not part of the professional rules governing the conduct of lawyers, but rather a part of the rules of evidence. The rules of evidence are meant to guide the courts in determining facts. Because the privilege puts certain types of evidence off limits, because as the cases and evidence treatises sometimes put it, it is in derogation of the search for the truth. It is narrowly construed. The attorney-client privilege is much narrower than the ethical duty of confidentiality, which, as I've already explained, in most states protects all information relating to the representation of a client. In addition, the burden of establishing the privilege is on the party who asserts it. But where the privilege is established, it prevents the disclosure of the communication in question. So why are certain communications protected from disclosure? The idea is that the privilege will advance society's interest in compliance with the law. The attorney needs to get all facts in order to advise the client and to effect compliance with the law. And the lawyer, in turn, needs to be comfortable in giving the attorney all the facts. By preventing further disclosure, the attorney-client privilege encourages the client to give the attorney all the facts that are relevant to the matter. So as I said, there are three main aspects to the attorney-client privilege. First is that it must be a confidential communication. The communication will not be protected if it is not confidential. So that means that if a court concludes that there was no reasonable expectation of confidentiality, it will not create a communication as privileged. And that in turn means you need to limit the disclosure of communications if you intend them to be privileged. It doesn't matter whether the communication is oral or written. Privilege protects them both. But the privilege only protects communications, not the facts underlying those communications. So if an officer or employee learns facts relating to a company while doing his or her job, those facts don't become privileged just because the officer later tells them to a lawyer for the company. The officer would still have to testify regarding those facts, although the officer wouldn't have to testify about the communication with the lawyer. As the Upjohn case in the United States Supreme Court, which I will discuss further in a little bit, said a party cannot conceal a fact merely by revealing it to his lawyer. Now, the privilege is a two-way street. If the other elements are satisfied, it covers both communications from the client to the lawyer and communications from the lawyer to the client. That brings us to the second element. The communication must be between a lawyer and a client. Now, usually the question of whether the one party to the communication is a lawyer does not get a lot of attention. But there's at least one decision in which a court held that a communication with an in-house attorney who had left his bar membership lapse was not privileged. That case is called Gucci America versus Guess, and it's from the Southern District of New York. That decision, made by a magistrate judge, was ultimately overturned by the district court judge, who concluded that since the company had a reasonable belief that it was communicating with an attorney, the privilege would be applied. It seems to me to be the right decision, since the privilege should turn on the client's intentions. But there is at least a risk that another court will hold that the privilege does not apply in this situation. Well, that risk may be small, the consequences would be substantial. Moreover, being admitted to the bar supports the idea that the lawyer is rendering legal advice and acting as an attorney, and not in some other capacity when receiving the communication. As a result, it also helps in establishing the third element of the privilege as well, that the communication was for the primary purpose of obtaining or rendering legal advice. The rules for admissions for in-house lawyers differ from jurisdictions. Many states create special regimes for in-house lawyers, which permit the lawyer, for the payment of a substantial fee to represent the corporate employer and its organizational affiliates, but not other clients. If you don't get admitted either under the special in-house rule or under the general requirements for bar admission, the bar authorities may have a basis for saying you have engaged in the unauthorized practice of law. So that's one side of the communication between a lawyer and a client. Let's look at the other side, communication with a client. Now, when the client is an individual, it's self-evident who the client is. But when the client is an entity, it is not so easy to determine whose communication counts as a client's. There are two main tests here, the subject matter test and the control group test. The more commonly used test is the subject matter test adopted by the Supreme Court in Upjohn versus United States. Under this test, it doesn't matter what level the corporate employee has in the corporate hierarchy, as long as the employee's responsibilities included the subject matter of the communication. That's item C on the slide. And in addition, the communication, A, was made by the corporate employee to corporate counsel at the direction of the employee's superior. B, the superior directed the employee to communicate with counsel in order for the corporation to obtain legal advice. And D, the employee was sufficiently aware that questioning was to allow corporation to obtain legal advice. Now, this is the rule, the subject matter test, that applies in any case arising under federal law. And it has been adopted by a majority of the states, but not all. The other main test is the control group test. Under this test, it doesn't matter if the subject matter of the communication is within the employee's responsibilities. Communication will not be privileged unless the employee is in the control group. That is, unless the employee can act on any legal advice rendered or has authority to obtain legal representation on behalf of the corporation. This is the minority rule. It is the rule here in Illinois. It provides much narrower coverage than the subject matter test. Now, some states, including as best as I can tell, New York, have not yet decided definitively which rule to apply. As a result, whether communication will be considered to be with the client is more difficult to determine. That brings us to the last element of the privilege, that the consultation must be for the primary purpose of obtaining or rendering legal advice. That's usually not an issue for communications with outside counsel. After all, a client will not generally pay the fees for an outside lawyer to consult about anything other than legal issues. But because in-house lawyers often play different roles in a company, the same is not true for them. The company will usually have the burden of showing that the lawyer gave the advice in his or her legal capacity. For example, the New York Court of Appeals has held that the need to apply the attorney-client privilege narrowly is heightened in the case of corporate staff counsel, lest the mere participation of an attorney be used to seal off disclosure. That means that the more authority the lawyer has for the workings of the company, the worse the problem may be. The lawyer can make the relevant decision and not just advise the company's decision. Court might well decide that the communication was for the primary purpose of obtaining business advice, not legal advice. The way the communication is disseminated may also undermine the privilege. Email makes it easy to share information with a bunch of people who might have a need for the information. But that's fine for many communication, but not so fine for ones that are seeking legal advice. Concern is that a document sent to a lawyer and a number of other people will be deemed not to be asking for legal advice, but for business advice. As a related point, people sometimes think that a memo to a group of people in the company will become protected merely because it is copied to a lawyer. That is not correct, or at least not necessarily correct. Court will need to consider whether the communication was for the purpose of obtaining legal advice. Courts are disinclined, to say the least, to find a privilege in this situation. One federal court has said, documents prepared by non-attorneys and addressed to non-attorneys with copies routed to counsel are generally not privileged since they are not communications made primarily for legal advice. The point here is that to make it more likely that a document or other communication is treated as privileged, you need to tell the people you work with, if they want legal advice from you, they need to make it clear that that is what they are asking for, and to limit who receives the communications. And even if your people don't do that, you should emphasize that you're providing legal advice. Start your response with something like, you asked me to consider whether the company is permitted to do X under the relevant law. To use the cliche, make it clear that you're wearing your legal hat. And limit who receives the communication. Privilege can be waived. Since the privilege belongs to the client and only the client can decide to waive it. In the context of a company or other entity, this means that when you're having a discussion with an employee about a legal matter, especially one who doesn't deal with legal issues generally, you should emphasize that the company can decide to disclose what the employee is telling you. The employee may well believe, because he or she is talking to a lawyer, that all of this is confidential and will never come out. Because you're representing the company, that may not be the case. Now, as I say on the slide, a court might decide that the privilege is waived if the company or other client puts it at issue in litigation or uses privileged documents to prepare a witness. In this sort of situation, you should have litigators already involved, so they'll be able to advise you on this risk. Risk that you need to think about before litigation arises is taking appropriate steps to prevent inadvertent disclosures. If you don't, it might be considered waiver. And if you don't and there is inadvertent disclosure, it might be considered waiver. In a lot of ways, this can be looked at as a corollary of the requirement of confidentiality. The client does not try hard enough to keep the material confidential. The court may not treat it as confidential. In those instances where a lawyer has represented two parties and the two parties are later at loggerheads about that matter, the privilege will probably not apply as between them. So I've put this under waiver. It's really more a question that, or a support of the proposition that the privilege cannot be asserted against the client. And finally, there's a question of what happens to the privilege when the company or its assets are sold. Most of the case law says that when control of the company is transferred, the privilege transfers with it. That may lead to some interesting questions. Say that a company sells a subsidiary, and after closing, company has a dispute with the buyer. Can the seller company protect the pre-closing communications between in-house counsel, who are still with the seller, and officers of the subsidiary, who are now with the buyer? Seller will face an argument that it cannot, because the privilege belonged to the sub and was transferred to the buyer. It may be appropriate to say how the privilege will be treated in the transaction documents to avoid questions like this. Now, because the privilege is a legal rule, there are, of course, a number of exceptions to it. First one that I've listed is one that can apply in shareholder derivative suits. In a derivative suit, the shareholder purports to stand in the shoes of the company. The shareholder stands in the shoes of the company, the theory goes, then the shareholder should have access to the company's documents, including its privileged documents. Courts have accepted the company's management owes duties to shareholders, but because these sorts of claims do interfere with management's ability to manage the company, the shareholder must show good cause before they can get access to privileged material. That's a proposition that was first held, or most notably first held, in a case called Garner versus Wolfenbarger. That's why it's sometimes called the Garner exception. Similarly, in a dispute between a majority and minority shareholder, the minority shareholder may argue, the minority shareholder may argue that the company cannot assert the privilege against it. The second exception I'll discuss is the fiduciary exception, which has a similar rationale. Under the fiduciary exception, where a client obtains or receives the legal advice in a fiduciary capacity, it cannot assert the privilege against the beneficiaries on whose behalf the advice is being sought. For corporations, this exception comes up most frequently in ERISA cases. Some of you may have been following discussions about the Department of Labor's proposed expanded fiduciary rules, which apparently will not come into effect anytime soon. The DOL rules would have expanded who should be considered a fiduciary under ERISA, and the fiduciary exception would have applied in more instances. Although this was not the focus of the discussion about the fiduciary rules, it's another reason why the rules were so important, because they likely would have made the fiduciary exception to the privilege even more of a trap for the unwary. Finally, a court will not apply the privilege if it concludes that the client sought the services of the lawyer to enable or aid the commission of what the client knew or reasonably should have known was a crime or fraud. So far, we've only talked about privilege under U.S. law. Non-U.S. law adds a whole different complication. Let's mention that some countries do not recognize the privilege for in-house counsel on the ground that the in-house counsel is not independent of the company. These countries include, I am told, France, Italy, China, the Czech Republic, Luxembourg, and Sweden. And foreign courts may not recognize the privilege even if the advice is given in a country that does recognize the privilege for in-house counsel. On the other hand, some U.S. courts, although not all, will recognize the privilege for in-house lawyers in foreign countries, even though the communication was in a country that does not recognize the privilege. So these are the takeaways about privilege. First one is to know the applicable law. This is especially important for here in Illinois, since we're the most populous state that uses the control group test. You need to recognize that even if the subject is where the control group test applies, you need to recognize that even if the subject matter of the communication is within the corporate employee's responsibility, your communication will likely not be protected if the employee is not part of the company's control group. Again, when you're providing legal advice, make that clear. Wear your lawyer hat. And advise your coworkers that when they want to get legal advice from you, they need to limit the dissemination of the communications, not transmit them far and wide within the company. And then be careful to keep them from being accidentally disclosed. So that's all I have to say on these subjects today. I have left a few minutes for the question and answer portion of the program. Again, for those of you with questions, you can submit your questions electronically via the Q&A widget. If I don't get to your question during the program, I'll make every attempt to follow up with you after the program. So let me take a look at what we have here. First question is, since the privilege belongs to the client and is for the benefit of the client, what was the rationale for disallowing privilege where the client thought he or she was consulting with counsel, but counsel negligently did not renew bar registration? Well, the implicit proposition in your question was the one accepted by the district court in overruling the magistrate judge. I think that the magistrate judge was just taking a formalistic view that the lawyer, the quote lawyer, was not a lawyer because it was no longer was a member of the bar, and so that was the proposition and the rationale behind it. Someone asked, will the U.S. court recognize that non-U.S. lawyers as having privilege if their own law does not? At least some U.S. courts have recognized that proposition. Not all. I think that the rationale is that courts, the interest of judges in applying the rules in their own jurisdiction. I believe that's mostly the rationale behind it. I agree that other courts will say, well, if it's not protected in the jurisdiction where it was given, it shouldn't be protected here. So someone has asked, can you give examples where law firms have sought overbroad advance waiver of conflicts in the engagement letters? Well, from my perspective, that never happens. But we always are asking for things that are reasonable. But I will say that sometimes clients have a different perspective of that. They will think that we've asked for too much, and they'll tell us that. And so there will be some negotiation about that. What I will say is that even if it's broad, it sort of has to be detailed. Again, one that we used when we were trying to get a full advance waiver refers to litigation, arbitration, and other adversary proceedings, as well as transactions and the like. And so I'm not. I think that's the best answer to that. In slide 11, someone has said in-house counsel representing both sides on an intercorporate dispute, who's to complain? In most instances, that is true. No one will be able to complain. Every once in a while, we will get instances, however, where the in-house counsel represent both the company, which is, let's say, the parent company, as well as a predominantly owned subsidiary, not wholly owned, because of whatever agreements between the company and the subsidiary. There could be, in an instance like that, minority shareholders who could complain. There could also be questions about if that subsidiary is later spun off. I suppose this is in part questions about privilege, but especially where if there's going to be questions that the interests of the subsidiary were not adequately represented, that the legal advice was improper because of the person who acquired it. Someone has asked, can a corporation hire an attorney who comes from a party with whom they are negotiating a contract if the new attorney did similar work for the prior employer, but did not work on the new employer's matter? For example, the attorney does a tech transaction for a tech company and then goes to a customer to do tech transactions, including occasional transactions with the former employer. That's a good question, and that goes to what extent matters are substantially related. My view tends to be that would not be substantially related because in that instance it isn't a specific transaction. But the question, the definition of substantial relatedness deals with what the lawyer knows and whether what the lawyer knows could be relevant to the new client and adverse to the old client. It's possible that a court would conclude and that the former client would think that the lateral attorney does have information that's relevant, even if it's not specific to the particular transaction in question, based on the representation of the former client. We're somewhat concerned about this ourselves, when this is likely to apply. We think that it should be kept relatively narrow, but there can be questions, and it may be appropriate to avoid heartburn and problems down the road to have an understanding of what to use this example, the tech company, the company from which the lateral has come, will and will not object. Does the attorney-client privilege also encompass files, e.g. documents sent by email by and to the lawyer from the client and vice versa? If the purpose of sending those files are to, I guess there are two aspects of that question. The fact of the sending of the documents and the request for would be privileged if the purpose of sending those documents would be for the purpose of obtaining legal advice. or to provide legal advice if the lawyer is sending it back to the client. However, if the documents whether the documents themselves, and let me back up a second, in that question or in that situation, there would be there might be I would take the position that what documents the client decided to send to the lawyer would be privileged, so that you would not have to say, you would not have to disclose, I asked the client for information on the subject and I sent the following documents. On the other hand, the documents themselves might or might not be privileged if they were created expressly for the purposes of obtaining legal advice. Yes, they should be privileged. But if they were created in the normal course of the company's business or the client's business generally, the fact that they were then sent to a lawyer doesn't make them privileged. But the communication of those documents to the lawyer would be privileged. When is a corporate client considered a current client? For example, if a firm agrees to a firm's outside counsel terms of engagement, but is used sporadically but on an ongoing basis, is that considered a current client? This comes from someone that thankfully gives us lots and lots of business, and so that doesn't occur with us and you. But I will note that it's a recurring problem for us as well. It's hard to know sometimes whether we'll be considered a current client in precisely those sorts of situations. We are concerned that the client will say, yeah, I go to Mayor Brown on a regular basis or on tax questions. And these come up and they're one-off tax questions and they're relatively small. But we think of Mayor Brown as our lawyers for that. We're concerned that in that situation, we will be considered a current client, or excuse me, their current law firm. They will be considered our current client. We try to say in our engagement letters that we are acting for the law for the client only with respect to the specific questions that they've asked, and when that work is over, our representation will be over, and that in any event it will be over after a year has passed since the last time we have done work for them. But that is sometimes a recurring issue for us. We'd like to take on a matter for someone who really probably isn't a current client, but we're concerned that, especially if it's litigation, someone will try and raise an argument. I'm being told I'm allowed to answer one more here. Is using privileged and confidential attorney work product at the beginning of emails useful? I always think it is useful for the simple reason if you're in litigation, it will stop someone from actually producing the document without at least thinking about whether it's privileged or work product. By calling it privileged or work product, on the other hand, it doesn't make it privileged or work product. You have to actually make sure that it meets the requirements. So thank you all. That wraps up today's program. And on behalf of Mayor Brown, I want to thank you for your time. There are a number of questions that I didn't get to, and I will try to address those as I can. Hope you found this program useful. A recording and link to the materials from this program will be distributed by email in the next day or two. Thank you again for participating, and this concludes our webinar.